So now we'll deal with the Article 31C, and Article 31C is the final exception to fundamental rights. As I already told you that Article 31A, Article 31B and Article 31C, they are the exceptions to the fundamental rights. Article 31A, I told you that it saves certain laws from 5 categories of laws, like the acquisition of estates, the modification of the rights of directors, the management of the properties by the state, the modification of the leasing rights, etc. And then I told you about Article 31B having the 9th schedule in the Constitution of India by the first amendment, and it saves the almost 282 acts from being challenged, right? And now it is open to judicial review, and all the acts added to the 9th schedule after 1973, they are open to judicial review. Now we will deal with Article 31C. I have already told you something about Article 31C under Article 14. I told you a line that when the Article 31C comes in, Article 14 goes out. I have already told you that Supreme Court gave a ruling, and in that ruling Supreme Court said that when Article 31C comes in, Article 14 goes out. This I have already told you. Now we will deal in detail with Article 31C. Article 31C, it was not in the present in the Constitution of India, but when the government of India, when the Parliament, it started to do the developmental works and it started to implement the directive principles of state policy, the fundamental rights of people, they were violated, and the people approached the courts, and usually the court, they give rulings, and finally to nullify these rulings by the verdicts by the court, the Parliament made various amendments, and one of the amendments was 25th Constitutional Amendment Act of 1971. And this amendment Act of 1971, it was intended to insert Article 31C having two provisions. Having how many provisions? Two provisions. So 25th Constitutional Amendment Act of 1971, it added Article 31C, and Article 31C, it contained how many provisions? It contained two provisions, right? The first provision of Article 31C, very important, it provides that no laws that seek to implement the directive principles of state policy, some of the socialistic directive principles which were specified under Article 39B or C, 39 clause B or 39 clause C. So Article 39 clause B or Article 39 clause C in the part 4 of the Constitution of India, they are the directive principles of state policy, they are the socialistic directive principles of state policy, right? So Article 31C, the first provision, it says that no laws that seek to implement the directive principles of state policy enshrined in Article 39 clause B, clause C, they shall not be said to be void on the ground that they are in contravention with the fundamental rights conferred under Article 14 and under Article 19. I told you that the Parliament made certain laws which were found to be in contravention with Article 14 and 19. So Supreme Court, it said that they are invalid, but Parliament, it made the 25th Amendment Act and it added Article 31C to protect all those laws which give implementation to Article 39 clause B and clause C. So all those laws which dealt with the implementation of direct principles of state policy under Article 39 clause B and Article 39 clause C, which we will deal under the directive principles of state policy. So all those laws that were made to give effect to Article 39 clause B and Article 39 clause C. The Article 39 clause B, it provides for it says that the state shall not direct its policy towards the securing that the ownership and control of the material resources of the community are distributed. So it deals with the good distribution of the material resources. And Article 39 clause C, it deals with what is known as the economic system, and it prevents the concentration of wealth, right? So we will deal with these articles in detail in directive principles of state policy. Here you have to remember only one thing, that Article 31C provision, first, it protects all those laws which give implementation to directive principles of state policy from being challenged that they are in violation with Article 14 and 19. That means if you see this article, it says that the laws giving implementation to Article 39B and C, they have an upper hand as compared to the fundamental rights. So somehow it says that this directive principle, it is superior than the fundamental rights granted under Article 14 and 19. We will deal with it later on, but here you have to remember only one thing, that all the laws which were made to give implementation to the directive principles of state policy under Article 39 clause B and C, they could not be challenged on the ground that they are in contravention with Article 14 and 19, right? And this provision, it was validated by the Supreme Court of India in the Keshavananda Bharati case. In the Keshavananda Bharati case in 1973, the Supreme Court validated that this provision, it is okay. Then there's a second provision in Article 31C, and this is a very confusing provision, and it says that this is very interesting. It says that no law containing a declaration, any law that contains a declaration that it is giving effect to such a policy, it is giving effect to the directive principles of state policy, it shall not be questioned on in any court on the ground that it does not give effect to such policy. What I told you, that Article 31C clause 2, it says that a law, it cannot be challenged if it contains a declaration that it is giving effect to a directive principles of state policy, it is giving effect to a policy. It cannot be challenged whether it is giving effect to the policy or not. Mere declaration gives it a safety. Mere declaration of the fact that it is giving effect to a policy, the law can be saved from the judicial review. But this provision second, it was declared invalid in the Keshavananda Bharati case, right? So in Keshavananda Bharati case, the Supreme Court of India, it did the judicial review of Article 31C, and it said that in Keshavananda Bharati case, the Supreme Court said that provision first is okay, but provision second of Article 31C is invalid. So provision second, it may be present in the Constitution of India, but it is invalid at present because the Supreme Court said that it is invalid, right? Because mere declaration was saving laws from the judicial review, which is obviously unconstitutional and invalid. Then what did Parliament do? Parliament, in order to nullify the effects of the ruling of Supreme Court in Keshavananda Bharati case, the Parliament enacted the 42nd Constitutional Amendment Act of 1976. This 42nd Constitutional Amendment Act of 1976, this is very important and this is very interesting. Since Keshavananda Bharati case, it invalidated the second provision. So 42nd Constitutional Amendment Act of 1976 enacted by the Parliament, it widened the scope of Article 31C's first provision. So what did this say? It said that we cannot challenge any law that is giving effect to any of the directive principles of state policy, right? I told you that Article 31C first clause, first provision, it provided protection to the laws which give effect to the directive principles under Article 39 clause B and C. But the 42nd Amendment Act of 1976, it widened the scope of first provision. It said that all the laws which give effect to any directive principle of state policy, and not just the directive principle of state policy under Article 39 B and C. So 42nd Amendment Act, it widened the scope of provision first, and it made amendments to the provision first, and it gave protection to any of the laws which give implementation to any directive principles of state policy that is enshrined in Part 4 of the Constitution. And hence it gave protection to all those laws giving effect to any directive principle of state policy. But later the Supreme Court of India, it made another judicial review in Minerva Mills case, in Minerva Mills versus Union of India in 1980. In this case, Supreme Court of India said that this amendment, that is 42nd Amendment, which increased the scope of provision first, it was invalid. It was declared unconstitutional, invalid. So what is the present position? So the present position is that Article 31C, although it contains two provisions, but only one provision has been said to be valid, and this provision is that we cannot challenge laws which give effect or which give implementation to the directive principles of state policy under Article 39 clause B and C from being challenged that they are in contravention to that fundamental rights under Article 14 and 19. So this is all about Article 31C. So the exceptions to the fundamental rights, we have completed the exceptions to the fundamental rights, and now in our next class we will deal with the Article 32, the very important article, right to constitutional remedies, right? So this is all about the fundamental rights from Article 12 to Article 31 A, B and C. Thank you so much for watching this video lecture. Have a nice day, stay home and stay safe.